All right, so here we go. Greetings to our speakers and approximately 700 registrants from all corners and time zones. I am Athita Kominder, head of the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific in Incheon, Republic of Korea, and I will be moderating today's discussions on dispute resolution in the digital economy, or DRDE, which will be recorded. I joined UNCITRAL RCAP and moved from Thailand to South Korea in 2019 when UNCITRAL's work on the digital economy was taking off. And since then, RCAP has been co-organizing various events with regional stakeholders in law and business on the topic. It is therefore my honor to moderate today's sessions, comprising experienced and diverse experts from within the AP region and beyond. To those who joined the DRDE series since its inception in February of this year, I hope you are not too disappointed to see me instead of my colleague, UNCITRAL Legal Officer Jae-Sung Lee, who along with our Japanese colleagues is one of the focal points of the DRDE dialogue. I promise Jay is still here, lurking, and will be moderating tomorrow's discussions with much flair. So allow me to express profound thanks and gratitude to the Japanese Ministry of Justice and the Japan International Dispute Resolution Center, who are co-hosting this event with the UNCITRAL Secretariat. Arigatou gozaimasu. Thanks to your never-ending efforts, it has been an extremely productive and thought-provoking 2 months of DRDE discussions. Now, during our trial run yesterday, one of the experts gave a good nutshell summary of where things stand with DRDE. He said, and I quote, "There are lots of things going on and none of us are quite sure what to do with it." So this is precisely why the Commission tasked the UNCITRAL Secretariat to commence research on issues identified in Japan's proposal on stocktaking of dispute resolution in the modern context, noting their relevance to the digital economy and COVID-19 related developments in the area of dispute resolution. To tell us more about the Secretariat's undertaking and developments, I now pass the floor to the Secretary of UNCITRAL, my boss, Ms. Anna Juvenbue, for opening remarks. Anna, lovely to see you, and you have the floor for 5 minutes.
Thank you very much, Athita. And I will start with the traditional greetings for online meetings. Good morning, good afternoon, and good evening to all of you joining our event, our 2-day event, and joining us for this culmination of a 2 months exploratory meetings that we held on various aspects of what is in fact a broader project in UNCITRAL. Let me just put it into the broader context of UNCITRAL's exploratory and preparatory work now on the legal issues of the digital economy. UNCITRAL has started in 2018 to explore various aspects of digital trade, and particularly looking how the digital technologies impact, sometimes disrupt, and sometimes also facilitate trade. And we've seen in the very unfortunate COVID pandemic that we're all still suffering from, that the digital technologies have helped a lot in streamlining and overcoming all the hurdles that the pandemic and the absence of in-person contacts has brought about. So as part of this exploratory and preparatory work, 2 of our member states have presented us, or 3, say, of our member states have presented us with proposals to also look at the dispute resolution side, or the dispute resolution arm of digital trade. And they have done so with various focuses in mind. We first received a proposal by Israel, supported by Japan, to look into dispute resolution in high-tech related transactions. We then received a proposal from Japan to take stock of the recent developments in the area of dispute resolution brought about by the pandemic, but the pandemic being only, I would say, a trigger to what was already there and was not maybe used as much, which was all the digital technologies in dispute resolution. And last but not least, Hong Kong, a special administrative region of China, has launched recently a center to exchange a platform, to exchange experience and exchange best and good practices among states and stakeholders, and particularly the industry, to look into digital resolution and particularly online dispute resolution, or I should say dispute resolution provided or serviced by platforms. So we are looking into now weaving together these different aspects of what is a broad project, and we hope to bring it to the Commission in July with a very solid report, not only of the various exploratory meetings we had this year, but also on the findings of today's and tomorrow's webinars. So I can't tell you how much I'm looking forward to these discussions, to the guidance we will receive from the experts, and to once again thank our member states, particularly Japan and Israel, and Japan here for hosting us, for the further exploration of what I think is maybe the topic of the century, but at least the topic of the at least decade to come. So thank you very much. I'm looking very much forward. I'm going to do it exactly like my colleague Jay, switch off my camera, lurk in the corners, but listen to everything you discussed today. Thank you very much.
Thank you very much, Anna, for giving us that comprehensive overview in precisely 5 minutes. I now pass the floor to Mr. Takashi Takashima, Senior Attorney, Ministry of Justice of Japan, to share an overview of the Japanese stock-taking proposal. Takashi, you have the floor for 5 minutes.
Thank you, Atita, and thank you from my end to Anna as well for the wonderful opening presentation. As was referred to in Anna's presentation, Japan's proposal on stock-taking of dispute resolution in the modern context will be discussed further at UNCITRAL's upcoming session scheduled for late June to mid-July. While our proposal received broad support at the previous Commission session last September, we understand that it is for us to make an even stronger case to make our proposal take shape. By way of background, triggered by the pandemic, what prompted us to put forward this proposal was that, especially in this rapidly digitalizing world, we thought all states and stakeholders would greatly benefit if the Secretariat implemented relevant activities to collect and compile information on the ground regarding the recent trends in the field of dispute resolution. We expect that sharing of information will be enhanced through those activities, serving to achieve a technical assistance purpose, and also that they will lay the groundwork for future legislative work that may be carried out in UNCITRAL. Speaking of information sharing and technical assistance, I feel it being relevant to touch briefly on our domestic situation in terms of digitalization in the field of dispute resolution, which shows that we are also in need of information and support to better adapt to the evolving circumstances. One might wonder if Japan is really in need of technical assistance because of its longstanding position as a provider of technical assistance. Though the current administration considers digitalization to be one of its pillars among the various policy objectives, the speed of digitalization, including in the field of dispute resolution in Japan, has however been relatively slow. It is generally acknowledged that this is because Japan's society has become sufficiently developed without digital means, and with an increasingly aging society, the users do not necessarily have a strong appetite to change the status quo. It appears that many in Japan still do not strongly feel that significant change is necessary. Calls for digitalization have not been as strong as in other parts of the world. Instead, the downside of digitalization has frequently been emphasized. For this reason, all in all, it has led Japan to take a rather cautious approach in terms of digitalization in the various fields, including in dispute resolution. Thus, we are not necessarily the front runner in the use of technology in the field of dispute resolution. To put this in a positive context, we see ourselves in an advantageous position in the sense that we are able to carefully assess and learn how we might best incorporate technology in this field. We think that there will be so much that Japan would benefit from information sharing were this proposal be implemented. While progress in terms of digitalization may differ in each and every jurisdictions, we also believe that there will similarly be benefits to be reaped from this project by other states and stakeholders as well. At the same time, we also are convinced that there are areas in which Japan can contribute to this project by sharing its experiences. The dispute resolution system in Japan is generally considered to be just, fair, and effective. We have nearly 100 years of experience in mediation. Dispute resolution institutions in Japan are appreciated as being highly competent in handling large volumes of information and capable of communicating effectively with the parties with a view to substantially ensuring the rights of the parties to present their case. To better adjust to digitalization, there is clearly a need to extrapolate from and refine essential elements in traditional practice, and we stand ready to share our experiences in this regard. To improve the overall quality of dispute resolution in the digital era. In the course of our workshop, we will be learning from presentations and exchanges with prominent experts in the field from around the world. I am sure that the discussion will greatly contribute to making this project meaningful and very much looking forward to it. One final word in concluding. Japan counts on the support of states and relevant stakeholders with respect to its proposal and wishes to reiterate its commitment to extend its support to the activities to be carried out by the Secretariat in any way that is needed. Let us make this project an effective vehicle for information sharing and a source of good rules and governance. Thank you, and with this, I hand over back to Athita.
Thank you very much, Takashi, for that overview and also for placing what we are discussing today in context and highlighting also its benefits and potential implications. So thank you very much. Now, before we start the speaker sessions, now that we've concluded with the opening remarks, some organizational issues, if I may. JIDRC has already circulated speaker bios, so with the speaker's permission, I would refer you to that document for details. On organizational issues for a lively and efficient discussion, we will have session 1 and 2 presentations back to back, followed by a 10 to 15 minute Q&A. This would then be followed by session 3 and 4 presentations back to back with another 10 to 15 minute Q&A, during which questions could be addressed to all speakers. There may be some divergences to accommodate speakers who can only join us for a short period. You will see this is the case already with our first speaker, and I thank all speakers again for their understanding and flexibility. The Q&A box should be open for participants to submit questions, so please feel free to do so. I will be monitoring the questions and will try to address as many as possible to our speakers. For speakers, you have 8 minutes each, and we thank you for sharing your screen if you have PowerPoint. If assistance is needed at any point, please let us know. I will raise my index finger, hopefully that's polite, to indicate when you have 1 minute remaining. Like thus. So I think my colleague Jay had promised day 2 speakers he would dance to indicate time's up. So I invite him to turn on his camera to do the same for our session as well. Finally, I have been informed by JIDRC and Takashi that the speakers link for days 1 and 2 are the same, which is why you might see the presence of all our speakers on your screen. I would therefore ask that all day 1 speakers keep their cameras on throughout today's discussions, but remain muted, please, except during your own session. And that day 2 speakers, please keep your cameras off and remain muted. Thank you very much. With that, let us start our first session on updates on the exploratory work on technology-related disputes. I pass the floor to Mr. Cedric Saba, International Cybersecurity and IT Law Director, Ministry of Justice of Israel. Cedric, you have 8 minutes, please, and welcome.
Hi, thank you so much, Athita. It's an honor to take part in this event. I'd like to thank Japan's Ministry of Justice, UNCITRAL, and the JIDRC for their invitation to take part. And a special note of our appreciation to Takashi and Japan's Ministry of Justice for their collaboration. Our work together that began in 2019 generated a robust conversation between UNCITRAL members and stakeholders regarding the interplay between dispute resolution and technology. And after extensive discussions with our colleagues at UNCITRAL, including notable contributions from the Czech Republic, we remain convinced that this work is critical. Before getting into the Japan-Israel proposal at UNCITRAL and the experts group meeting that took place, I'd like to mention that we in Israel have made it a priority to enhance our legal framework for cross-border dispute resolution. And just 2 weeks ago, we published a draft bill to adopt UNCITRAL's model law on international commercial arbitration and a draft bill to ratify the Singapore Convention. They're open to comments by the public, and if you're interested in following up on this, we invite you to follow the social media accounts of Israel's Ministry of Justice and of our Deputy Attorney General for International Law, Dr. Roy Scheindorf. In addition to these developments, we've been working to improve the legal framework that applies to our tech industry, which is so vital to Israel's economy, and this is where the Japan-Israel proposal comes into the picture. So for those of you who may not be familiar with it, I'll just briefly note that it highlighted 3 areas of dispute resolution that seem to warrant particular attention in high-tech disputes: timeframes that need to be much shorter so that the dispute can be resolved within a few weeks or a couple of months at the most. 2 is a mechanism for ensuring that experts are brought into the process as early on as possible. And 3 is mechanisms for giving the neutral access to highly sensitive trade secrets while protecting confidentiality of the evidence. In last year's annual commission session, UNCITRAL recognized the importance of this topic and decided to undertake exploratory work. And pursuant to that decision, UNCITRAL convened an experts group meeting that Israel's Ministry of Justice helped organize, and that took place a few weeks ago. So in this presentation, I'll provide a short overview of the discussions that took place in the meeting in the hope that it can stimulate further discussions here. Over the course of the meeting, we challenged experts to try and address the question posed to us by attorneys who represent high-tech companies and VC funds. Namely, how can we facilitate dispute resolution that is agile enough for the fast-paced world of high tech, and also that the parties can really have faith in? We also needed to address more technical and bureaucratic, but no less important questions about UNCITRAL's involvement in this work and the potential scope of this work. For example, would such a system for dispute resolution replace already existing mechanisms, such as arbitration rules, or do we need something, a non-prescriptive instrument that can be combined with an existing mechanism? Is there a need for different procedural arrangements specifically for high-tech disputes? And also, given that this proposal arose in UNCITRAL, it was important to address the question of how future work on this topic fits within UNCITRAL's mandate of harmonizing international commercial law. The experts that took place in the discussion came from various backgrounds: academia, attorneys for high-tech companies, international arbitrators, and representatives of the finance sector. There were some really interesting takeaways that maybe paved the way for future work at UNCITRAL. One was that the speed of dispute resolution is critical to high-tech companies, and current timeframes just aren't quick enough. And this in turn results in damage to a company's access to justice, since their companies are deterred from beginning any kind of dispute resolution, preferring instead to settle claims under suboptimal terms or abandon the claim altogether. We had a really interesting discussion as to what kinds of timeframes are appropriate, particularly in light of UNCITRAL Working Group 2 that finalized its expedited arbitration rules last week, and a big congratulations on that. It's a significant achievement in its own right, and these rules, once adopted by UNCITRAL, will certainly be quite relevant for tech disputes. So do we need something even faster than that? And are shorter timeframes realistic or even desirable, given the need to ensure due process and proper examination of all the evidence? And the discussions, I think, led us to this idea that we could create an instrument that doesn't necessarily prescribe mandatory alternative timeframes, but harnesses the flexibility of existing dispute resolution rules, both within arbitration and mediation, so that the neutrals or the parties can shorten existing timeframes as needed. There was also a really interesting time-saving idea of compartmentalizing the case in different subcases so that a particular technical issue doesn't need to be reviewed by both a technical expert and the neutral. For example, within a given case, you could have an expert appointed by the arbitrator make a determination regarding a specific set of facts, and that would be accepted on its face by the arbitrator. And this would eliminate the need for the arbitrator to reassess everything. An issue that arose time and again was how to ensure that expertise is baked into the process at the onset. Advantages and disadvantages of pre-existing lists of experts. Does it enhance trust in a meaningful way? And also, given the complexity of tech disputes, is it possible to have a set list of experts? There were also proposals for appointing an expert immediately when the dispute commences. We were also informed of the importance of confidentiality and data protection within the arbitration. It's not unique to high-tech disputes, but the issue seems to come up more frequently in those cases because companies guard their algorithms tightly. So here it could be useful to have some kind of default confidentiality arrangement that applies to the neutral, the parties, and the experts. There seemed to be consensus that if a new instrument were to be developed, it shouldn't take the form of another completely new set of dispute resolution rules, but rather maybe some kind of guideline document or a toolbox for high-tech companies and dispute resolution professionals seem more appropriate. A toolbox that could include model clauses and specific tailored default rules for tech disputes. This would circumscribe the work to be done by future UNCITRAL working group and facilitate the work of practitioners in the future by providing like modular solutions that feed into existing rules and mechanisms without having to start from scratch. As lawyers often do, we had a discussion on definitions. What constitutes a tech dispute? It's important to clearly define the scope of whatever mechanism will be created, and there are advantages and disadvantages to a definition that's either overly broad, overly specific. My own personal view is that it's better to adopt like a broad, non-prescriptive definition to allow flexibility to the industry. Ultimately, if UNCITRAL will be producing a non-binding toolkit rather than a new set of rules, the definition should be enabling and not limiting. And one interesting question that arose was how civil law and common law traditions impact how parties approach dispute resolution and their expectations of the process. And here, harmonized standards regarding mediation and arbitration can sort of level the playing field and transcend common law versus civil law constructs. And in this regard, I think it's safe to say that UNCITRAL is a natural forum to create such harmonized standards. Also in high-tech disputes, it's crucial, specifically for SMEs. And UNCITRAL enjoys widespread recognition, and its dispute resolution mechanisms are widely used, so that there's a built-in advantage for UNCITRAL to take a prominent spot in this growing niche sector. And lastly, one personal observation. Right now, we're in the midst of the Jewish holiday of Passover, which commemorates the Jews' freedom from bondage and exodus from Egypt, some of you may know. And during the first night of Passover, we have a tradition of reciting a short song which repeats the phrase, "Why is this night different from other nights?" In other words, what's so special about this holiday that requires us to reenact the Exodus, reread text every year that we're already familiar with? And the answer given is that even though we already know the story, there's an intrinsic value in paying special attention to it because it informs and educates generations to come. So even though it's a punctual event that takes place once a year, it has very broad, enduring effects. So maybe you can see where I'm going with this. A recurring theme in the discussions at the experts group meeting was, why are tech disputes different from other types of disputes? Arbitrators and mediators already have flexible rules that can be adapted to the needs of pretty much any given type of dispute. And I think we saw over the course of discussions that even though this baseline is true, there's value in focusing attention to these disputes because they have cross-sectoral repercussions. And the insights and balances that can be achieved in crafting a kind of legal toolbox for high-tech disputes can be scaled up and replicated to other industries. So that's it for my takeaways on the experts group meeting. Thank you.
Thank you very much, Cedric. Wow. So philosophy, a little bit of religious insight, as well as high-tech and dispute resolution all rolled into your 8-minute presentation. Thank you very much. Let's see. I know you're pressed for time. Did you want to answer a quick question here, or maybe we can wait?
I'm flexible.
Okay, all right. So maybe we'll wait because one of the issues that you had talked about was harmonization, one of UNCITRAL's mantras, and that is actually the topic of our next speaker, Mr. Yoshi Takatori, Executive Director of Japan Arbitrators Association, who will be discussing specifically how to harmonize perspectives of common and civil law jurisdictions for high-tech dispute resolution. So Yoshi, the next 8-minute is yours. Thank you.
Thank you very much, Theta. Yeah, it's very much honor for me to be a speaker for this great session by the UNCITRAL and the JIDRC and the Ministry of Justice, Japan. And actually, as the Cedric mentioned, we are doing the expert group session from the all over the world. And actually, I'm the one of the expert for that group session. And also, I understand that the one of the big purpose of the UNCITRAL is harmonization. So harmonization is the key word for the perspective of the common law and the civil law jurisdictions for those high-tech dispute resolutions. So, for example, like standard essential patent dispute resolution, including the multi-jurisdictional litigation or dispute, whatever. Although the scope of the high-tech resolution, dispute resolution is kind of on the discussion whether these such kind of a standard essential patent disputes should be also involved or not, something. But still, those type of high technologies characteristics for like very short survival period in the market and impact on the users and the impact onto the market, we should definitely have there is some sort of a good options for the users. And today my role is from the Japan side. And as Takashi mentioned, we have a long history of the mediation and amicable legal culture. So talking about such hybrid type of the common law perspective and civil law practice for high-tech dispute resolution. And although the definition of the dispute resolution should be including the arbitration and mediation, but should not be within the purely for each one. So we can just call it as a dispute resolution. But still, as the convenience, I'm trying to mention and speak from the aspect of the arbitration for the high-tech disputes. So as the opening remarks, the remote due to the COVID-19 impact, such remote itself could be quite beneficial for the availability of the resource. Resource means the arbitrator and experts for the high-tech technologies assessment or something. And what's the role of the arbitrator? And the common law style quite adversarial, party versus party. And then compared to that, the civil law style is a more parental or interactive style. For example, JCAA has recently implementing the so-called interactive arbitration, in which the arbitrators are like some sort of a disclosing their observation on the case on the half. So depending upon the parties and the nature of the case, especially for the high technologies disputes, we should think about such arbitrators' role and role as the expert and or collaboration with the internal experts. That can be online, and then should co-work as the hybrid combination of the common law and the civil law style, especially for the case including the multi-jurisdictions. And then how to keep and how to increase such resource. So should do training for the arbitrators on technology side and or train technology engineer to be arbitrator or mediator. That's also one alternative. And because as I am the Japan chapter of the CIR's co-head, and the CIR Chartered Institute of Arbitrators was founded by the engineer, not by the lawyer, So founded aiming at the sufficient and accessible resource. So that's one way, one possibility. So broad, and then concretely, the broad discovery or limited discovery, that's also under discussion, and or more specific discovery on the high technology side. So maybe we should have a double standard between the high tech evidence and other general evidence as a protocol guideline. As Cedric mentioned, we should have a protocol or some sort of a guidelines, not as the solid rule. So that's also under discussion. Then mediation. So common law style globally utilized is historically it's a more facilitative rather than evaluative, which has been civil law style. So for example, in Japan, as Takashi mentioned, the mediation long history mainly by the judge, and actually Tokyo District Court has the some department combination of the expert and the mediators, and then judges. So that kind of impact input can be, contributing to the such discussion. Then a common law type facilitation for business and the high-tech significance in the speedy market. As I mentioned, the high technologies value is a quite, surviving very short time, and then seeking for the common business interest among the parties, because all involved parties should have a resolution in a speedy way. Then confidentiality, cost, timing, and such should be aiming at the win-win resolution, not only for the parties, but also for the market, the users, because high technology like 5G or standardization patent, such type of technology is a very, very, high-end valuable in the market. So, and then expertise for some evaluation assessment on the high-tech side, including the value of a technology and complexity based upon the civil law type practice is important. So for that aspect, I think civil law type of evaluation sort of a protocol could be contributing, and co-work with the expert, technology expertise and legal expertise and the facilitation should harmonize. So then question is how? So mediator can be trained again, and or engineer can be trained. So such, dual direction could be considered. And so, for example, as I mentioned, the Japanese judicial system has the ADR by judge and appointed expert as a co-mediators. So that's one example. Then I've made so such combination for harmonizing of the across jurisdiction. So identity of the arbitrator and the mediator, that's also discussion. Divided strictly without the prejudice or continuing with the observation, impression of the case for speed up. That's also the civil law type of contribution could be considered. And how and when experts should be involved through the ARB-MED process, and then facilitation, evaluation, negotiation, communication. So need consistency and speed. So those factors should be important, and concrete measures for the hybrid or harmonization. If multiple jurisdiction governing law, legal culture should have some protocol guideline, as I mentioned. So we should have, and we should provide some options for the users. So then elements, requirements for the efficient arbitrator mediator, expertise in high-tech elements and the commercial business disputes and legal dispute resolution capability. So then lastly, the resource and the easy access to expert and arbitrator and mediator online advantage should be utilized, and how to utilize previous arbitration or mediation for subsequent procedure or a settlement. So without prejudice is good or not, we should consider. And such continuing process for speedy resolution would be valuable in terms of the comprehensive resolution and a consistency. And so maybe we should have a precise evaluation by the technology on the technology side also should be concretely discussed. So very, very speedy, but thank you very much. That's from my end. Thank you.
Thank you very much, Yoshi, for that fascinating presentation, which, like Cedric's, raises many intriguing questions, which we will return to during the first collective Q&A. But before that, we will delve into the second session first, focusing on innovative dispute resolution platforms, as well as dispute resolution in the platform economy. So the second session is, it starts with an update from IGLIP on online dispute resolution. And I now give the floor to Mr. Ian Lee, Acting Senior Government Counsel, Department of Justice, Hong Kong SAR. Ian will add to our treasure trove of DRDE acronyms by telling us more about IGLIP. So Ian, the next 8 minutes is yours. Thank you.
Thanks, Athita. Hi, everyone. My name is Ian from the Department of Justice of Hong Kong. Congratulations first, and thanks to UNCITRAL, the Ministry of Justice of Japan, and the Japan International Dispute Resolution Center for hosting this event, and particularly for inviting me to introduce Hong Kong's recent initiative, which, as Athita said, is an acronym, the IGLIP on ODR. So the IGLIP on ODR stands for the Inclusive Global Legal Innovation Platform, IGLIP, on ODR, Online Dispute Resolution, which has been set up earlier this year with the support of the DOJ Project Office for collaboration with UNCITRAL. This project office was established to work on the cooperation envisaged under the Memorandum of Understanding between the Hong Kong government and UNCITRAL for collaboration relating to international trade law, which was signed in November of 2019. The objectives of the DOJ Project Office are to keep track of new developments and challenges arising from the use of emerging technologies in international trade, to support and enable the establishment of networks or platforms which facilitate continued discussion and collaborative knowledge sharing and creative problem solving in exploring these developments, and to enhance cooperation in exploring the use of innovative solutions to provide answers to existing legal problems and to promote such solutions globally. At present, the IGLIP on ODR has nearly 30 member experts from all the continents, except Antarctica, obviously, who meet and share with us their experiences on the topic of emerging technologies and how they intersect and impact on online dispute resolution. The Project Office provides secretarial support to the IGLIP on ODR. The objectives of the IGLIP on ODR is to keep track of developments in and issues arising from the application of emerging technologies in online dispute resolution, and to provide a platform which acts as a forum to facilitate discussion, collaborative knowledge sharing, and creative problem solving. Another objective of the IGLIP on ODR is to explore, discuss, and develop innovative legal tools to address novel issues arising from the use of ODR and to facilitate the harmonization of new and existing legal tools. Online dispute resolution is indeed a subject close to our hearts. According to a recent study by the Asia Pacific Economic Cooperation, APEC, Business Advisory Council, 94% of micro, small, and medium enterprises, MSMEs, reported that dispute resolution was one of the greatest challenges they face when trading across borders. Against such a background, the APEC Economic Committee endorsed the APEC Collaborative Framework for online dispute resolution of cross-border business-to-business disputes. I referred this to the APEC ODR framework in 2019 to encourage MSMEs in tapping ODR for negotiation, mediation, and arbitration for business-to-business disputes. In April of 2020, Hong Kong, China has opted into the APEC ODR framework. Locally in Hong Kong, we have also launched the COVID-19 ODR scheme last year in response to the pandemic, which is in line to the APEC ODR framework to provide speedy and cost-effective means to resolve such disputes, especially for those involving MSMEs that may be adversely affected or hard hit by the pandemic. The scheme is operated independently by eBram Center, a non-profit-making, non-governmental body to provide ODR services to the general public and businesses, in particular MSMEs, involved in low-value disputes. With that in mind, the above international and local developments have illustrated the importance of ODR and also the need to address various novel issues arising from the use of ODR. Going back to the IGLIP on ODR, we have currently held one IGLIP on ODR meeting, which was in collaboration with UNCITRAL early this month, where we did a stock-taking exercise of what the current trends are in this area and generally to get a feel of where things stand. The meeting discussed the topics of platforms for international trade and the linkage to dispute resolution, and this topic focused on the linkage between digital platforms or electronic platforms being used for trade and how they may be used for resolving disputes. The other topic discussed by the meeting was online platforms for international dispute resolution, where we focus on the utilization of ODR solutions to resolve cross-border disputes, in particular in light of the global pandemic. Some of the challenges and questions identified include concerns of due process and procedural fairness when using ODR, and the enforcement of ODR outcomes. There is also the big question of whether current legal and regulatory frameworks are sufficient to address the emerging technologies used in law and in online dispute resolution. And if not, how new rules and regulations should be drafted to adapt to this technology. We are now preparing a summary of the meeting, which will be turned into a report. We will also pass the report to UNCITRAL for consideration of possible collaboration with IGLIP on ODR in the relevant areas of work relating to the digital economy. We hope that the IGLIP on ODR could provide a useful platform for experts around the world to discuss and explore innovative legal tools to address various issues arising from the application of emerging technologies in ODR and to facilitate the harmonization of existing legal tools, as well as possible development of new legal tools in collaboration with the relevant international organizations, such as UNCITRAL. So this concludes my brief introduction to IGLIP on ODR, and I hope you will keep an eye out for our events and publications. Thanks a lot.
Thank you very much, Ian. We will come back to you soon for the Q&A, but first I'd like to turn to the final speaker for session 2 before we start the first Q&A, and she is Ms. Teresa Rodriguez de las Heras Bayal, Associate Professor of Commercial Law, University Carlos III of Madrid, who will discuss recent trends and challenges of dispute resolution in the platform economy. Teresa, I really hope I managed to retain passable pronunciation of your name following yesterday's mini tutorial. The floor is now yours for 8 minutes.
Thank you very much. Good morning, afternoon, and evening. Thank you very much for the kind and excellent pronunciation of my long and probably complicated name. Thank you very much for the invitation. It's indeed a pleasure, it's an honor to be part of this panel discussion. Thank you very much for the organizer for inviting me to share my views on dispute resolution and the platform economy. I'm going to share my screen in order just to illustrate some visually some ideas that I would like to share with you. And the starting point of my talk is that the digital economy has become today a platform economy. Platforms are the most important, the prominent, the dominant organizational model in the digital economy. Most of the innovative business model, most of the disruptive business model that we look around, we see around, they are triggered, they are based, they are facilitated by platform-based model. And this is very important because dispute resolution has to be contextualized in this environment, in the platform economy. And more important, has to be considered a vital component of this beautiful, complex and fascinating machinery that I called the legal anatomy of platforms. Because what is indeed a platform from a legal point of view? A platform is a centralized scheme based on a bundle of contract that, and this is my main thesis and theory here, that try to emulate a legal system. The most fascinating conception of a platform is that a platform try to be a private legal system, try to create their own jurisdiction based on contract. And that is a very important idea because we are going to contextualize, we are going to frame all the regulatory challenges of dispute resolution within this idea, within this important conception of platforms as private jurisdiction, as private legal system. As you can see on the screen, a platform is based on a centralized scheme where the operator carried out the very important and basic business activity of indeed operating and managing the platform. And on the other side, we have the community of users that join the platform for the purpose of carried out a specific social interaction, a specific economic or non-economic activity. All this structure is based on a combination of contract. The first one and very fundamental is the one entered into by the user and the operator, that is the called membership agreement, according to which the user commit to abide by the terms and conditions, the rules book, the policies that the platform provide for this particular community. I say that a platform is a private legal system because the most important function of the operator are indeed regulate, supervised, and facilitate dispute resolution. As platforms are based on contract, we have an extraordinary malleability, an extraordinary flexibility to design a platform according to different models. We have platforms where regulation and supervision function are clearly centralized, and is the operator the one who adopt the rules and indeed supervise the compliance or the infringement of the policies of the platform. We have, however, the very famous, popular, we are so familiar with, structures where the supervision is decentralized. We have social networks where users assist the operator to detect infringement and to report this infringement to the operator in order to detect an illegal content, an infringement, a fake news, or simply a content or a message that is not in compliance with the internal policies of the platform. In some cases, due to the need to enhance the impartiality, the perception of neutrality of the supervision, or even the dispute resolution, these functions are outsourced to a trusted third parties for the purpose of relying or increasing the reliance of the user on that particular function. So we have a platform where there is regulation, the rules adopted by the operator in order to provide all the different elements that has to be regulated within the platforms. We have mechanism to supervise the infringement and therefore detect the possible compliance. And then we have, of course, the third fundamental pillar of any jurisdiction, any legal system, the provision of dispute resolution mechanism, the ODR. In the legal anatomy of platforms, dispute resolution is a fundamental component. And this fundamental component has been also recognized in the most important and recent regulatory trends that we can see around the globe. If we take a look at the map that you can see on the screen, the different initiatives adopted by either international, but in most cases, regional organization are based on regulating the different dimension of platforms, either regulating the platform to user relationship in order to mitigate this probably asymmetry that the relevant role of platforms is creating. Other initiatives are more based on the idea of the liability regimes of platforms. Others are more based on the idea of data sharing and data access within the platform and among the different platforms of this beautiful ecosystem of platforms. But I would like just to stress, in order to connect to the last part of my talk, I would like to stress how in most of the recent initiatives trying to regulate platforms, there is a clear effort, a clear attempt to include complaint handling mechanism and to promote dispute resolution suited, well accommodated to the platform economy. Let me just finalize focusing on this idea of dispute resolution mechanism within the platform and in the platform economy. The first idea that I think is very important is that on the one side, we have online dispute resolution as a component of the platform in order to solve dispute between the users of the platform. And we also have platforms whose main function is indeed to provide dispute resolution solution to others platforms around the digital economy. That is a very important conception that we have to bear in mind. The second idea that I would like to share with you is what is the conception and the delimitation of a scope that we should take into account in order to define dispute resolution in the economy. If we take a look at different layers of dispute resolution in a very broad concept in the platform economy, we see how we have different levels from the purely complaint handling mechanism between the users and the platforms to content moderation mechanism such as report system or takedown system as well. And then we also have online dispute resolution mechanism in order to solve dispute between and among users. What are the challenges? Let me please conclude. Definitely, it is a case for harmonization. Platforms are global. Platforms are not linked to a specific territories, and therefore harmonized universal rules are absolutely critical. What are the main problems? Procedural rules. Are the internal policies of the platform the procedural rules that we are going to apply for the purpose of the dispute resolution proceeding? What are the principles that we should apply to these internal procedural rules? The valid consent. Can we consider that the clause included in the standard terms of the membership agreement are valid manifestation of consent in order to be bound by these internal policies and in particular dispute resolution? Very important. Let me conclude. Recognition and enforceability. What is indeed the value and the nature and the legal effect of this kind of output of the internal dispute resolution mechanism of the platforms? Are they arbitral award? Are they simply mediation transactional agreement? What is the value of that? And what is the applicable law? The internal rules could be considered the new applicable law of those dispute resolution that take place within the platform. These are the challenges that we have definitely to address in all the projects, all the initiatives that we are indeed at the moment carried out for the purpose of harmonizing dispute resolution in the platform economy. Thank you very much.
Thank you very much, Teresa, for that intriguing presentation, which also goes to all of our first four speakers. Thank you very much. Can I now invite all of our first four speakers to turn on their cameras and teleport themselves back on screen so we can do the initial Q&A for sessions 1 and 2. So thank you. We have some questions from the floor, which I will try to include. I think I'll just start off with a simple question. While your presentations are very intriguing, I regret to say my questions are probably much simpler and thus not as intriguing. So let me just start off by asking each of you, where do you think your respective exploratory initiative, project, hypothesis is heading, along with any anticipated or promising developments? So I guess that would be an initial question I would throw out to you, along with anything you might want to add to your presentation in light of what the other speakers might have said. And then maybe I'll just read the questions from the floor as well, so you can pick which questions you might want to answer first. So one of the questions we have from the floor, I think this is addressed to Yoshi. Have you considered a co-mediation model where one of the mediators is a technical expert? So there's that question. And I think this one is for Ian. I think this is probably the simplest one. Please share the full form of IGLIP. So I think they probably want it in written form, and maybe someone can answer in the chat. Thank you. There was another question, and let me see if I understand it correctly. They had asked about harmonizing ADR with the local level economy. So I think for that, maybe Ian can talk a little bit about MSMEs and the benefits that IGLIP and ODR might have for that. Anyone else could also chip in. Cedric could talk about high-tech dispute resolution and how that benefits MSMEs. And there was a question also on remote hearing, whether remote hearing can help avoid due process paranoia, in the sense that can arbitrators authorize themselves to allow only a certain number of documents in remote hearings? So those are the full batch of questions that I have right now. Let's see. So maybe we'll start with Cedric because he's a little bit pressed for time. So Cedric, please.
Sure. Thank you. Thank you so much. So regarding where we're going with this, currently we're still processing all the fascinating discussions that were held, and we're planning to continue collaborating with UNCITRAL and hopefully work with the 2021 Commission to plan a way forward. Also, I do want to thank Yoshi and give credit to Yoshi for giving us all this, for participating in the experts group meeting and giving us all this really interesting outlook on the common law versus civil law perspectives and the relation with dispute resolution. So ultimately, it's going to be up to the Commission to decide, but I think that the work done so far shows that there's a real appetite for some more research and some kind of official UNCITRAL text. And the discussions at the experts group meeting should help the Secretariat produce a report that will be discussed at the Commission. We're considering different options on how to prepare for the deliberations in a possible UNCITRAL working group. One idea we're considering is to work with some experts on developing like a basic draft document of the proposed toolbox, and that could be like a starting point for further development by a working group. And such a document could be helpful to provide like a framework for the discussion, to provide a focus and also facilitate efficient discussions, with a view to develop some kind of outcome within 4 to 5 working group meetings. But obviously, we hope that debate's going to take place at the Commission. Regarding the benefit to MSMEs, so yeah, I didn't get into all the specifics, but our work on this really came from the bottom up, where discussions with MSMEs showed that they really do need some kind of unique dispute resolution mechanism, because regular mediation and arbitration is just overly costly and cumbersome. When you're talking about like a startup that just has like a small amount of capital to play with for a short amount of time, and then a dispute arises, it could really destroy a startup after a year of its existence. So there really is a need for something unique that can help them in those cases. And regarding the due process paranoia, so yeah, that's also an issue that we grappled with in the course of the discussions. Really, it's the question of balancing between having something that is very, very quick, but at the same time something that doesn't that allows the parties to state their case properly, and where you find that balance. I think one interesting point to make here is that, from our discussions at least, for small and medium enterprises, sometimes they seem to prefer a quick resolution that is not 100% fair in the usual like judicial sense of the term. They'd rather have something that resolves the case and gives them certainty quickly, rather than a full process where, you know, hundreds of pages of documents are disclosed and analyzed. I don't think that the very fact of having discussions online, like online hearings, in and of itself hampers due process. Maybe in certain cases it would, but right now, especially with COVID, we're seeing how so much can be done remotely. So I'm not sure it's a significant issue.
All right. Thank you very much, Cedric. I know you're pressed for time, and this is also a holiday, a working holiday for you, I guess. So thank you very much for joining us through the Q&A. All right. Now I will just turn to Yoshi, because one of the questions was specifically addressed to him. Of course, he could answer any of them. So the question was about the co-mediation model, where one of the mediators is a technical expert. Yeah.
Yeah, that's a very good question. And actually, the co-mediators, one of the mediator is expert, and one of the expert is a lawyer or a judge or a mediator. That's definitely quite essential options. And actually, as a little bit touched in my presentation, the Japanese mediation style by the Japanese court litigation has such option. Actually, the decision maker, the judge, is co-working with the co-mediator who is expert. So, and I have experience on the for my clients on the high-tech dispute resolution, and that worked very efficiently. We need to have some evaluation and assessment by the experts from the engineer's eye, and also we should have such legal eye by the judge. So we can maybe import such kind of options into the ADR, private ADR area. That's my short answer. So then I'd like to address some questions for our goal is to which direction we should heading is we need some useful options and such device for the users, and accessibility, and such sufficient resource. So then lastly, the very interesting question for the due process paranoia questions. I think due process paranoia is quite some obstacle, and then whether the such online operation and the online web hearing can resolve it and avoid it. So I'm the chair of the web hearing committee for the JIDRC's side, and so that's one sense could be true, but another observation is the such due process web hearing online operation might be increasing the due process paranoia. On the other hand, for example, like how to avoid coaching through the witness examination, and how to make objections through the online witness examinations, such kind of things. So it's quite new issues also coming up for the due process. And if we are failing of such due process through the online operation, then that could be triggering the setting aside or challenging litigation later. So the answer is yes, but that might be increasing. Another due process paranoia could be. So that's what we should take care very diligently. Thank you.
Thank you very much, Yoshi. We have tons of questions flowing in, which show how engaged our audience is. Let me turn now to Ian, because in addition to questions asking what IGLIP stands for, thanks for answering that in the chat box, there are also some other questions. This one talks about, so they're asking whether IGLIP on ODR is already running and in transformation, or is it still in the planning stages, exploratory or setting up phase, and how is project management for this being run, and in which stage is the project currently at? So,
I guess IGLIP on ODR has been established, and we've had our first meeting. So the thing about the IGLIP on ODR is that it's a platform for experts to come together to share their experiences, and also to facilitate, for example, studies or reports that may be of use. Turning to one of your questions, Athita, about where this is going, IGLIP on ODR is in its early stages. I previously, in my short presentation, stated that our outcomes is to produce reports and papers consolidating our findings. And also, I think one thing that should be mentioned is that we want to do dissemination, knowledge sharing, capacity building exercises on this subject. So in the future, we may hold conferences, workshops, other type of events. But one thing that's even more important is our collaboration with UNCITRAL, and I think it depends on our collaboration and on our discussion with UNCITRAL, as in how we can most effectively work with UNCITRAL to harmonize, as in another question that was asked. That's our plans or goals. So in relation to the harmonization question, as in how we can harmonize different laws and regulations, I think to harmonize, we first have to look at what the situation is in different places and in different jurisdictions. So what the laws are in different places, and to do that, the IGLIP on ODR is trying to facilitate this process by drawing on the knowledge and experiences of experts from all around the world. So with these knowledge and experiences, we can start to try to figure out some tools to assist in this harmonization process.
Thank you very much, Ian. I see Anna has popped back on screen and she is smiling widely. So thank you, everyone. Thanks to Hong Kong DOJ for their constant support as usual. Let's see, I'll turn to Teresa now, and then maybe we can loop back to the other speakers because the questions keep coming in. So Teresa, someone had asked whether Professor Bael would have any suggested solutions to your own questions on your last slide. Another question asked how you think consent to ODR is included within the terms and conditions of a platform. So I think those are two initial questions thrown to you, but maybe Ian can chip in too. There was another question on ODR. What are the considerations in terms of confidentiality and privacy of the parties, taking into consideration the various vulnerabilities of the web? So, yep.
Thank you very much. All the questions are indeed very pertinent. So what I'm going to do is just to focus on three main ideas that I hope could help to the audience. The first idea that is very important is, let's bear in mind that when we are trying to regulate platforms and how they organize internally dispute prevention and dispute resolution, what we are doing is to limiting the parties' autonomy. Because what they are doing, the platform is doing, is to deciding whether the contract that has been concluded with the user, what are indeed the terms and conditions, what are going to be the condition, regulating everything that happened within the platform, including how they solved certain dispute. This is very important because we can't simply focus our approach on these parties' autonomy's limitation. Because they are gaining such a popularity, because they are affecting very important fundamental right, because of that, maybe certain limitation has to be set out in this party's autonomy. That could provide us some guidance in the reply to the question about how to give a reply to my question. It could give us some guidance about what could be the kind of solution that at a harmonized level we could explore and we could think about. Certain duties related to the dispute resolution implementation internally in order to guarantee impartiality, in order to ensure the equal treatment of both parties, in order, for example, to guarantee that the consent provided by the parties is a consent that is conscious and free enough. And of course, in order to ensure that the procedural rules that are indeed internal, purely contract-based decision by the platform, they are totally aligned with this international standard that we consider fundamental to guarantee that the outcome of this process has certain value and is going to be enforceable. So this is a first idea that I think is very important. The second idea is, of course, we are going to face additional challenges if we are in platforms where consumers or weak party, including SMEs, are involved. If we talk about business to business platforms, probably the problems that we are going to face are definitely limited, but it's going to be higher and higher complex if we are going to talk about business to consumer, peer to peer, or even SMEs. And maybe the third idea that is very important is, are we in a position to accept that a platform could decide internally that all the dispute could be solved as contractual and transactional decision? Do we accept that this first level is acceptable, is admissible, because it's important enough, because we are solving in a very expedited, in a very speed and efficient way certain problems? If we accept that, so now the question is, are we going to give any value other than simply internal contractual decision to these kind of outcomes? In the line, for example, with the UNCITRAL and the New York Convention, the UN New York Convention on Arbitral Award, are we considering this kind of approach, harmonizing not only the internal procedure, but also as well, what are going to be the characteristic of this super efficient, very quick outcome of dispute resolution? That would be my first insight for the purpose of further discussion. Thank you very much for the question. And thank you, Adita.
Thank you. Thank you very much. I know Ian could probably answer some of the questions too. More questions are posed here on iGlip. I think, but for now, we're going to move on to the next round of presentations, and then we will have a general Q&A after sessions 3 and 4, so we could loop back to you. Now, for our eager participants in the audience, if we don't get to all of your questions today, I will pass them on to Jay tomorrow, because we have a global roundtable of all the discussants, and we might get to them there. Otherwise, you can send us your questions by email, and we'll try our best to get feedback to you. So thank you very much. And with that, I think I can say that the first Q&A seems to have you thirsting for more presentations on other equally fascinating dimensions of DRDE, dispute resolution in the digital economy. So our next session, session 3, focuses on the use of technology in international mediation, which Yoshi had foreshadowed in his presentation a little bit. Now, as you all know, the Singapore Convention on Mediation is UNCITRAL's latest treaty. It's off to a remarkable start, having already entered into force only a little over a year since it opened for signing. The Secretariat is therefore closely following with much interest mediation-related developments. Now, I now give the floor to Professor James Claxton of Rikkyo University to share insights regarding good practices in online mediation. James, good to see you here. I think this is the second or third recent mediation event I've moderated with you on panel. So now the next 8 minutes is yours. Thank you.
Well, thank you very much, Nathita. It is nice to see you again. I am grateful for this opportunity, and I thank UNCITRAL, the Ministry of Justice of Japan, and the JIDRC for including me. I also commend Japan's proposal to UNCITRAL to take stock of dispute resolution in the digital economy. It is a subject that could not be more timely. One effect of the COVID-19 pandemic has been an increase in the use of online mediation. Mediators and businesses are now more familiar with online platforms and seem likely to use online mediation more in the future. This makes it important to think about how proceedings are conducted online to ensure that technology is an advantage and not a distraction. With this in mind, I would like to raise two questions for your consideration and comment in this session. First, what online mediation practices should be encouraged? Second, how can online platforms be leveraged to make mediation accessible to more businesses? With the remainder of my time, I will provide some initial thoughts about these questions. For the past 2 months, I have been doing research on mediator perceptions about remote proceedings, primarily using a short questionnaire for mediators with online experience. The results of this study so far suggest two primary complaints about online mediation. Of the more than 150 mediators who have participated in the survey, about 75% report technical problems and about 55% report environmental distractions, including interruptions to participants joining from home or from their offices. There are various things that mediators can do to avoid such problems. For instance, mediators can request that participants sign an online conduct agreement that commits them to join the mediation from a private space and to assure a strong, stable, and secure internet connection. An online mediation meeting can later be arranged between the mediator and the participants to confirm the suitability of the connection and joining environment before the mediation. This will also provide an opportunity for participants to familiarize themselves with the technology. More than 40% of the mediators in the survey report difficulty building rapport and personal connections with parties online. This issue warrants particular attention because the response is not so obvious. Some things that mediators can do to build rapport include meeting with parties less formally before the mediation and possibly spending more time in private sessions during mediation than in joint sessions. Consideration should also be given to how to engage parties more fully in the process. In this regard, research at Stanford University suggests that watching your own reflection on screen can be distracting and even stressful. Based on this finding, mediators might encourage parties to use the self-hide view on the online platform so that their cameras remain on, but they do not see themselves. Research also shows that we think better when we move than when we sit motionless. Mediators can recommend that participants stand occasionally or that they sit at a comfortable distance from their screens to allow for natural body movements. Accounting for these softer aspects of online mediation may improve the experience for participants and result in better communication. The second issue that I would like to raise is how online platforms can be leveraged to make mediation accessible to more businesses. The ease of joining mediation online rather than in person should make mediation attractive, especially where parties are geographically far from one another. One way to encourage greater uptake of mediation is to rethink the standard mediation process. A typical mediation conducted in person might bring the mediator, the parties, and their legal counsel together for a day of mediation at a determined location, such as the offices of a law firm or a facility with mediation rooms. Without the need for physical space or physical presence, different models of mediation are possible. The study I'm conducting suggests that experimentation is already happening. About 35% of mediators report that they have used more asynchronous sessions online, meaning that the mediator meets with individual parties without the other parties present and waiting. About 35% report that they have used more private sessions, and 30% report that they have taken more days to mediate disputes than they normally take with mediations in person. These results suggest that the inherent flexibility of mediation is being more fully realized online than might be possible in person. This flexible approach can make mediation more responsive to party needs and more accessible to parties. For instance, more than a quarter of the mediators in the survey report that online platforms have given them greater access to decision makers. There is also support that online mediation results are no different than results for mediation in person. More than 60% of mediators in the survey report no change to settlement rates online compared to in person. Meanwhile, a significant number of mediators report higher settlement rates online. The survey remains open, but the results so far suggest that online mediation is as effective as mediation in person, while offering a platform that is more cost-effective and more accessible to participants. And with that, I conclude my comments with thanks to you for your attention.
Thank you very much, James, and we will come back to you during the Q&A. I think a lot of facets of online dispute resolution, including mediation, are intriguing for our viewers, and so they've sent some questions. But before we get to that, I now turn to Ms. Kun Fan, Associate Professor of UNSW Law and Justice, who will discuss procedural fairness in online mediation.
Thank you. Thank you, Atika. And good morning or evening or afternoon, ladies and gentlemen. It's really a great honor for me to participate in the workshop. So I would like to thank UNCITRAL Ministry of Justice of Japan and the JIDRC for the kind invitation. So I will briefly talk about the online mediation and procedural fairness issues involved. As Mark Galanter pointed out, just as health is not found primarily in hospitals or knowledge in schools, so justice is not primarily to be found in the courtrooms. Ultimately, access to justice is not just a matter of bringing cases to a fount of official justice, but of enhancing the justice quality of the relations and transactions in which people are engaged. Online mediation is one way to enhance the justice quality of relations and transactions, but it also poses a number of challenges, such as due process, cybersecurity, data protection, confidentiality. So I will raise two questions related to procedure fairness in online mediation for us to consider. First, what are the key elements to determine whether disputants have experienced procedure fairness in an online mediation process? And second, what can be done to enhance the disputant's overall perception of procedure justice in online mediation? Procedure fairness is more salient in mediation where there's no evidentiary hearing, no decision maker, and no application of the law to the facts. In mediation, therefore, it is likely to be the procedural justice that will determine if the process is fair, satisfying, and legitimate to the disputants. This concerns the personal evaluation that the procedure is fair. Procedure fairness helps the parties, especially the weaker party, to make informed choice before a solution is achieved. To determine whether a procedure is fair, people also attend very closely to the interpersonal and relational variables of status recognition, neutrality, and trust, according to the relational mode of procedure justice. And this might point to some weakness of the online mediation, as James' survey also illustrated, that mediators find it's particularly difficult to build personal connection with the parties online. So what are the key elements to determine whether disputants have experienced procedural justice in an online mediation process? An empirical study identified the following 6 elements to measure and define procedure fairness in the online mediation, or ODR mechanism in more general. The first is equal treatment of the parties. The second, respect. So the neutral should behave respectfully to the parties, because when individuals receive respectful behavior from the neutrals, it enhances their satisfaction with the fairness of the procedure. Third, neutrality, which requires that the neutral be impartial and independent. Fourth, trustworthiness. Individuals will trust, accept, and follow the procedure and rules if they feel that the neutrals are fair. The fifth is consistency. There is indeed a need for consistent procedures in online mediation because they shape parties' expectation about procedure fairness. Individuals usually evaluate the procedure based on established procedure expectations. When this expected procedure is deviated from or inconsistent, then the party will perceive the process to be less fair. And finally, the sixth, ethical rules. The more individuals view the procedure as compatible with their ethical values, the more likely they will view the procedure as fair and therefore accept the outcomes. So in light of the above elements, to determine procedure fairness in online mediation, what can be done to enhance the disputant's overall perception of procedural justice? With respect to the equal treatment of parties, even though the mediators are not decision makers, they should still provide equal opportunity for both parties to present their case, to understand the opposite party's argument. This is an aspect of the voice criteria of the procedural justice. In ODR, interestingly, the power is often transferred from a party more comfortable with face-to-face communication to the one that's more comfortable with the technology. So it's also important for mediator to endeavor to minimize a party's power imbalance due to different technological skills. For particular technical issues, ICODR provided video mediation guidelines, which have some useful guidance, such as begin the session with everyone's video and microphone on as if they were in the physical room. And if one party gets disconnected, then suspend the session until they can rejoin. If a party's audio cuts out or becomes distorted, notify them once the audio resumed and ask them to repeat what was said during the outage. It's also a good plan to always have a backup option for sound, such as dialing in by the phone. On the issue of respect, this could include providing opportunity for disputing parties to have control over the process and the outcomes, equitable treatment of disputing parties, and also the proceeding should not be delayed without a reasonable cause. For the neutrality, also interestingly, James mentioned there is increasing use of the asynchronous sessions in online mediation. And when mediators meet with individual parties without the other parties present, it's particularly important for mediators to be cautious to maintain neutrality and ensure that the asynchronous sessions are conducted without bias or benefits for or against any party. Building trust is always challenging online because some of the psychological and emotional signals may get lost on the internet, but mediators can still build up the confidence from the parties in online mediation, ensuring the respect, neutrality, consistency, informed participation, including some of the suggestions James just mentioned. An ODR provider can also develop some evaluator system for neutrals practice that could enhance accountability and therefore build the user's trust of the system. For consistency, mediator could set up consistent and predictable process with the parties, agreeing on some cybersecurity protocol before commencing online mediation, which can also build up the trust. ODR providers could also adopt the rules and principles for their procedure from well-established ADR guidelines. And finally, on the ethical rules, ODR providers should have an ethical framework or ethical standard for ODR procedures. And to this end, the ethical principle for online dispute resolution provides some very useful guidelines and principles to foster ethical ODR systems and practice in both public and private spheres. So I will simply here conclude by quoting that the best way to predict the future is to invent it. The greater and better use of technology in dispute resolution is inevitable. So neutrals, service providers, and users should all prepare themselves for the digitalization process and to ensure technology better serves the delivery of justice. Thank you very much.
Thank you very much, Kun Fan. I see many questions popping up, but like with the first two sessions, I think we'll enjoy our back-to-back presentations for sessions 3 and 4 before launching our final round of Q&A. So as such, we would now enter our 4th and final session of day 1. Time has really passed by so quickly. And the 4th and final session focuses on the impact of the COVID-19 pandemic on dispute resolution in the digital economy. So our first speaker, arbitrator and Hong Kong SAR barrister Kim Rooney, will present her review of the global impact of the pandemic on commercial dispute resolution and relevant legislation on 23 jurisdictions. So a whirlwind global tour in 8 minutes. Kim, are you here? And if so, the floor is yours. All right, so I don't see Kim. Takashi, do you see Kim?
Unfortunately, I do not.
You don't see, okay.
I am ready to put slides on the screen.
Yes, I think she had emailed asking us to put her slides up, but I had thought she would be here to present the slides. All right, so maybe we can instead start with Stefano, because I know he is here because he said hello. Hi, Stefano.
Hello.
Buongiorno.
Hello,
yes.
Hello,
Hi.
nice to see you.
Nice to see you. I'm grateful the time frame is working out. Everyone is really so busy. So if I may, I think I will turn to you first. So Mr. Stefano Azzali is the General Director of the Milan Chamber of Arbitration, and he will be presenting the joint statement by arbitral institutions on the impact of COVID-19 for us. So Stefano, you have 8 minutes.
Thank you, Athena. And thanks to the organizer for the invitation, of course. Well, the impact of COVID-19 on arbitration, I would say that it has been negative and positive, both ways. But I do believe that after 1 year, I can say that probably there are more positive impacts than negative. And the positive impacts have been registered last year and today, and they might stay tomorrow. So I would split my short introduction in two. First, the past and the present. What was the impact? I would say the positive impact. I would say 3 major positive impacts. The first one, the activity, arbitration never stopped. The machine never stopped. It slowed down, of course, at the very beginning, the first weeks, because we were all quite shocked. I'm talking generally, because of course, I'm active within the Federation of Arbitral Institutions. I chair the federation, so I know what happened also with other colleagues. At the beginning, the first weeks, we were all shocked. We had to switch from in-person to a complete remote mode of working. But after a few weeks, the machine started to move again. So I think that the cases never stopped. And this because of the flexibility of arbitration, because of technologies, and also because of the inherent powers of the arbitrators, that in some way they could solve the problem. So in many cases, we registered, according to the main institutional data, an increased number of cases, reducing the speed of the arbitration proceedings, and sometimes also making more effective and more efficient all the process. So that's one major positive impact. The second positive impact, I would say, that is more related to the role of the arbitral institutions. I think that never as last year, users, and I'm thinking of course, final users like companies, in-house counsels, lawyers, and arbitrators, never as before, they realize how important can be an arbitral institution, the crucial role of the arbitral institution. In that specific situation, we were the only one to provide answers. Users, they were looking for answers. They were seeking answers. They were seeking suggestions, guidelines, because they were lost, like, I would say all the planet. They were lost. And the institution, of course, some more than others, but generally speaking, at least the major ones, they deliver, they gave answer, they gave instruction. They were a guide. And I think that, again, never as before, they found out that really an institution is not there simply to supervise or to look or to charge money. That's sometimes what we hear, but it's there to make sure actually three major goals: the integrity of the process, and that's what we all did, the continuation of the proceedings, so that never stopped, and the enforceability of the award. That they were the three major goals that had been reached thanks to the institutions primarily. So the third, and this is I would say the second major positive impact. The third one is the higher degree of collaboration among institutions. The major institutions, they collaborate since that's the history. We always work together among us. But in 2020, because of the COVID-19, we reinforce our collaboration, our network. And here we get to the declaration, the joint declaration by 12 arbitral institutions, plus one federation, that is the IFCAI, the International Federation of Commercial Arbitration Institutions. They signed a common statement, just saying we are here to help the process moving on, to guarantee the integrity of the process, to reduce time, to make the process more efficient, and to render enforceable awards. That was the major, the statement, and it was signed by the Cairo Center, the DIS in Germany, ICC, LCIA, the Stockholm Chamber, ICSID in Washington, Hong Kong Center, VIAC in Vienna, the Milan Chamber of Arbitration, SIAC in Singapore, ICDR AAA, and the Korean Center, plus the federation. So this was a positive impact because it's gonna stay. It will stay also tomorrow. We will work more together. As for the future, and these are the three major positive impact that I would say that the past and the present showed. As for the future, I think, and I hope, this is a hope, because the future, of course, I'm not a fortune teller, so I cannot say what will happen, but I believe that many of the positive impact are here to stay. And we will have more efficient proceedings. We will have faster cost control and probably answering more to the needs of the users. Of course, we cannot think that everything will be done remotely. There are phases of the process that cannot be done probably as good as they are in person. Like, for example, cross-examination of witnesses in a major construction case. That will take 2 weeks. It's very difficult to be conducted remotely. but many other phases will benefit of the experience. I hope they will benefit. We hope to benefit of the experience of last year and to render a service better for the users. I don't know how long did I take, but I hope not longer than 8 minutes.
You were perfectly within the 6 to 8 minutes range, Stefano.
Good.
So grazie. Thank you very much.
You are welcome.
And
Thank you.
timing worked out perfectly because now Kim is here online. So thank you. And I will revert back to you for our Q&A session after Kim is done with her presentation. All right, so thank you, Stefano. All right, our next presenter. Hi, Kim. Very glad you could join us. I know you're immensely busy, so thank you again. Now, excuse me. As I had mentioned, Kim is an arbitrator and Hong Kong SAR barrister, and she will present her review of the global impact of the pandemic on commercial dispute resolution and relevant legislation on 23 jurisdictions. So Kim, the next 8 minutes is yours before we turn to our final Q&A.
Thank you very much. May I thank you very much, UNCITRAL, RCAP, and the Ministry of Justice and JIDRC for this chance to share with you the results of a review of the global impact of the COVID-19 pandemic on commercial dispute resolution and relevant legislation. And I wish to present to you very briefly key findings as to 23 jurisdictions. And I do have some slides which I think colleagues are kindly going to show. And if I could ask them to put the slides up and go to page 2, but I'll keep speaking while we do. So thank you. So if you could go to page 2, please. This review, if we could go next slide. Thanks so much. Sorry, can you hear me okay? Thank you. This review was done under the auspices of Dispute Resolution International. This is the IBA's Journal for Contentious Committees, which I edit. And we have done 2 articles on the global impact of the pandemic on commercial dispute resolution. The first was published in October 2020. The link is there. The second will come out in the May 2021 issue. 46 people contributed from 23 jurisdictions, and I put those 2 articles together, but absolutely it was a collaborative effort. And we reviewed the impact on litigation and arbitration and ADR of the pandemic. And as I'll come to, there was a varying impact. Could you go to the next slide, please? The 23 jurisdictions were every continent in the globe except for Antarctica. And you can see that we actually reviewed about 9 jurisdictions in the Asia Pacific, but also jurisdictions, as you can see, in Africa, Europe, UK, MENAT, North America, and South America. Could we go to the next slide, please? Now, the trends, what I've tried to do here is just briefly speak about the trends, many of which are familiar to you, if not all. The pandemic has led to the development in some jurisdictions and accelerated use in others of online platforms in many different ways, including filing of cases, submission, exchange, and storage of evidence for hearings. And certainly there's been a mix and match of person, hybrid, and online hearings. And in a few jurisdictions also being used for circulation of decisions. One of the things that's been very striking is how adaptable mediation has been. In a number of jurisdictions, dedicated online mediation services have been established, and successfully. Next slide, please. As you know, many institutions in arbitration and similarly courts in multiple jurisdictions have issued practice notes and guidelines dealing with how best to provide service using online and electronic mechanisms and innovative technology. And so, as one would expect, they encompass fairness, efficiency, logistics. They deal with cybersecurity. I mentioned costs there because, interestingly enough, to date, many don't address costs. I'll come back to that. Next slide, please. When we did the article in October 2020, at that stage, the technology was mainly being used to provide filing, document storage, online hearings. But since then, for this May 2021 article, colleagues who've contributed have commented on increasing use of innovative technology, whether it's a blockchain for case management by a UK institution, many of us familiar with auto transcription, document management, also automated docketing. We all know about cloud storage, inferential artificial intelligence, and natural language processing and visual perception tools in both the US and China, among other jurisdictions. Other jurisdictions have been experimenting with flexible scheduling, and there's been differential views about whether costs are going up or down because of these trends, but I will come back to that very briefly. Next slide, please. So what are the issues? What became very clear, or what's become very clear, is different jurisdictions have shown a different capacity to be nimble and flexible and to respond quickly to the demands posed by the pandemic. In other words, some jurisdictions move very quickly, others very slowly. Initially, with the pandemic, as you know, many litigation systems were put on pause largely for a while, but as subsequent waves have come, that hasn't seemed to happen as much as courts have adjusted. One of the issues for jurisdictions where there's a value placed on the public having access to litigation, for example, has been how to procure that or secure that access. That's a work in progress, some jurisdictions doing it more successfully than others. It has been clear that there is an unequal access to resources. Some jurisdictions have better infrastructure, more funds to build out resources, more skill and expertise. It's something that will need to be addressed. As we know, there are inconsistent legal frameworks and practices. For example, in arbitration, some jurisdictions' legislation makes it very clear you can have online hearings, others are silent, others it's thought not. In terms of costs, while some jurisdictions have reported that costs are going down because you don't have to travel, you don't have to pay accommodation for witnesses, others have reported costs are going up because you do have to pay for the infrastructure to provide online hearings. I know I'm speaking quickly. I do apologise. I hope I'm keeping to time. But I do respectfully suggest this is a paradigm shift. I know that expression is used in many ways, but I think in my lifetime anyway, this is the first time we're seeing a new ways to resolve disputes emerging. And that's exciting. But it's also essential that we ensure that there is, well, I suggest it's essential we ensure there is some harmonisation of standards, of practices, and a way to ensure that the resources are available. And may I respectfully say that I hope that and think UNCITRAL can play a major part in this. So I thank you very much. I hope I've kept the time.
Perfectly, Kim. Thank you very much for your presentation. So now that our session 3 and 4 speakers have all delivered their presentations, I would invite all the speakers from day 1, from today, to pop back in. The questions keep popping up as well on different channels. So I'm just trying to go through all of them. Maybe I'll just read through all of them and then you can choose which ones you want to answer. Hello, Jay, and Jay is also here too. Now, some of the questions for our speakers, you might be able to answer in the chat box directly. So for example, Ian, if you're still here, someone had asked whether iGlip has an app or maybe a web page that they could go to for more information. So if there's something like that, maybe you could just post it somewhere or just let us know now and people can take note. Likewise for Stefano, someone had asked if they could get a referral to the statement that you were speaking about. I'm sure it's searchable online, so if you can talk about that, that would be great. Now, for other questions, let me see. Many. All right. So online mediation is a popular topic. The question is whether the biggest challenge for online mediation is the fact that parties are not in the same room. I think that question is equally valid for arbitration, so people could have a go with that. For mediation, they had asked how to develop empathy between the parties and the difficulty for the mediator to read body language and things like that if there isn't an in-person in-person element. To James, could you speak more on the asynchronous model? That's a question to you. And also on your good practices for online mediation, whether there's a fallback solution for enforcing, I guess, the best practices. I think we could weave this into what Yoshi had talked about regarding facilitative versus evaluative mediation. And Yoshi had suggested that in addition to aiming for a win-win solution for parties, we might also want to consider aiming for a win-win solution for market and users as well for the high-tech disputes. So interesting dimensions. Let's see. Someone had asked Kim for a link to the article. she mentioned. There's a question for online arbitral proceedings, whether COVID has impacted the volume of documents-only arbitral proceedings, how arbitrators handle examination of witnesses on highly technical or confidential issues when online examination might be the less appropriate method, but meeting in person isn't available. So I think those are the batch of questions that we have. Let me just throw two more at you, and then you can start answering. So to James and Kun, and maybe Yoshi and the arbitrators here in the room, could you please share your views on any differences between the use of technology in mediation versus arbitration, including due process concerns? And to our session 4 speakers, Kim and Stefano, UNCITRAL also has on its plate an exploratory project on measures that states are taking in response to the pandemic. Now, have any such measures been taken specifically in relation to dispute resolution as far as you know? So the very long list of questions. Let's see, maybe we'll start with our session 3 speakers first. So James or Kun, did you want to take a crack?
Sure, yes, I'm happy to. They're great questions, so many great questions. I think I'll start with differences in the use of technology between arbitration and mediation. Of course, there are many similarities, including the importance of preserving confidentiality online and assuring a reliable internet connection. But mediation online is slightly different, primarily because of the importance of the relationship between the party and the mediator. A mediator will normally need to build trust with the parties in order for the mediation to be successful. Mediators typically do this in large measure through communicating with parties during the mediation. And this implies, of course, that greater care may need to be taken to assure that technical conditions favor interpersonal connections. And there are various ways to do this. It's of course, a very difficult thing to build rapport online in the same way that one builds rapport in person. But using cameras, choosing the right camera angle, assuring good sound quality, limiting environmental distractions, taking regular breaks where the parties can get up and move around, all of these things may improve the quality of the communication. Of course, that demands the attention of the mediator at an early point to begin thinking about these issues and to make sure that they're accounted for.
Okay. Thank you, James. Kun, did you want to also answer some of the questions?
Sure. Yeah, I will start also with the question, like the difference about the use of technology in mediation, arbitration, and also the due process concern. I think James already tackled some of this aspect. And I think when it comes to due process, there's a key difference in mediation because the decision-making power remains with the parties. So the key, I think, to procedure fairness is really to ensure the informed participation, ensure that the parties make their informed decisions and are treated fairly and equally. And whereas in arbitration, since the arbitrator is decision maker, the key to procedure fairness is to ensure their right to present one's case, right? And there could be specific due process issue, as already mentioned in the earlier panel, like examination of expert factual witness, how to test the credibility and avoid counsel coaching. And there are a lot of, ways, those can be addressed. There are already good practice and protocols in place to address those potential concerns. And panel tomorrow might also have more detailed discussions. So that pointed to one of the questions, like the biggest challenge for online mediation. I think the biggest challenge is not that the part is not the same rule. It's really, the challenge of building trust in an online setting. But so ideally, it's because they could have some more emotional expressions and some random chat when you have the first in-person meetings. But the pandemic has just made online mediation a necessity because meeting in person is not available, right? So, but I just wanted to remind us that many of the things that we took for granted now may seem impossible 20 years ago, right? Just like email communications, now it become default. So people were at first very suspicious about online mediation, but I think with more successful stories, that will just encourage more users to try the process and build better practice and protocols so as to ensure technology will serve better to deliver justice and to make online mediation also more accessible. And that might also point to like some ethical questions. I mentioned about ethical rules. So like in the inability to rate emotional expressions, and some of the AI could actually detect parties' emotions, right? Should that be allowed even in online mediation session? I think those are some of the ethical issues that we should also consider. I just want to finish by saying that, when we talk about technology, we should also not lose sight of those human elements, which are important, particularly for mediation. And those are not reducible for matrix or not fully digitizable. So when, now there's increasing use of AI as well in delivery of justice, but, probably we should also bear in mind some limitation of this in terms of value judgment, human sentiment, human reasoning and emotions. And therefore the need to set proper boundaries and to consider proper ethical rules. Thank you.
Thank you very much.
Maybe really briefly, because there was a very precise question directed towards me by Dr. Rao. Asynchronous, that's a word, if you asked me the meaning of just a few months ago, I would not have been able to tell you. But now it's part of the lexicon about online dispute resolution. And the idea is pretty simple. Normally for a mediation, everyone would come together in a single place and the proceedings would happen in that moment and everyone would be there. And if the mediator met with a party privately, the other party would wait until that meeting was over and then engage with the mediator. And the idea of asynchronous is simply that all of the people don't have to be present at the same place at the same time. So the mediator could meet with parties on different days, for example, and that can be a real advantage in terms of scheduling.
Okay. Thank you very much, James and Kun. I think the enhanced access to justice element is a really important one. It's one that sometimes people often forget, in the heat of disputes and whatnot, but that is what we're doing. It's also one of the SDGs, which is so important to the work of the UN and UNCITRAL. So thank you everyone for helping to promote those SDGs by what you're doing. Now, turning to our session 4 speakers, if you wanted to take a crack at any of the questions, how about you, Stefano?
Yes, as for the impact of COVID-19 on the number of documents-only proceedings, I would say that I did not experience a higher number. I think because if the party wishes to hear a witness, they keep on asking to hear the witness. What I can see that in many instances, that's easy to be done remotely. And I get, because maybe one witness, with a very short witness statement, there is really not a big issue, provided that technologies are accessible to both parties and all the guarantees that we are aware of. But then for many other phases, it's only a different way to communicate and to get together. For example, the case management conferences, that's very easy to be organized by video conference. The same for deliberation of the award by the arbitrators. Then again, and I get to the second question about arbitration, What about the examination of witnesses in complex, on technical issues in complex, for example, construction cases? That's quite difficult. That's quite difficult because I have in mind cases where in the past, that I have no idea how they could be efficiently, let's say, conducted remotely. So there are still, I think, cases where it's difficult to proceed remotely. What I think it has to be clarified that the right, at least from my perspective, that the right to be heard, the right to present your case is a fundamental principle, but to the best of my understanding, and I would ask also Kim to see whether she found something different. To the best of my understanding, there is nowhere a right to be heard in person, a right to present your case in person. And I think that if you are aware of a very good, I think, decision of the Austrian Supreme Court of July 23rd, I invite you to Google, it's easy to be. That's exactly the principle where it is defined. You have a right to be heard, you have a right to present your case, provided that the technical tools are accessible equally, and they work, of course. There is no violation if it is done remotely. And I think that Supreme Court decision is really a cornerstone of the future, for the future, because I think that once we agree on those principles, then in the future, we will never be back to everything in person. That's my opinion. Oh, sorry, Athena. As for the joint declaration, it's on my screen if you want, but otherwise you can find on YouTube, and I can send you the link. Maybe it's easier rather than reading because it's a long string. So, but you can find it easily.
Okay. Thank you, Stefano. You might also want to just put the title of the joint statement in the chat box, and then all the participants could see and they can go search. So thank you very much, Stefano.
You're welcome.
Now, I will turn to Kim, and then, I will go to Ian a little bit, and then to Yoshi, and then we will close. We have about 3 minutes
Okay,
left.
so I'll be super brief. On the point that Stefano made about whether or not in arbitration there's any jurisdiction that requires an in-person hearing, I think there are a couple where the view is that from a jurisprudential angle, there should be a hearing does encompass some physical element, but certainly where the UNCITRAL model law applies and in many other jurisdictions, it's a question of having a hearing, not necessarily in person. Litigation is a different situation. There are clearly jurisdictions which do require an aspect of physical hearing in some litigation, such as Germany. And your question, Tita, I'll be super quick. 23 jurisdictions we surveyed, six jurisdictions did have some legislation for dispute resolution responsive to the pandemic, but in a piecemeal way, particularly in arbitration, piecemeal litigation. At least England, Turkey and US all amended their laws in some ways to make it clear you could have online hearings in appropriate circumstances. But thank you again.
Okay, thank you very much, Kim. And now is the perfect segue to Ian, because Ian had talked a little bit about Hong Kong SAR's, I think, COVID support relief for MSMEs and dispute resolution, I think. Is that right?
Yes. So during the pandemic, the Hong Kong government launched a COVID-19 ODR scheme, which is administered by the EBRAM Center, and basically that's a very cost-efficient, multi-tiered dispute resolution process where parties can very cheaply resolve their disputes in a very quick and effective way. If participants are interested, you can search online. I'll probably post a link to details of the scheme so that you can have an idea of what it entails. But yeah, for my part, I don't have anything to add except to say that we can see today that the discussion on ODR is very robust, and everybody is interested, which is a good thing. And I hope that IGLIP can work with UNCITRAL and collaborate to have further projects and works. So that's it for me.
Thank you very much, Ian. People are so eager to see the webpage that you're developing, asking about the app already. So we will keep an eye out for that. Thank you.
Yep, sure.
Thanks, Ian. Now, Yoshi, any last words?
Okay, yeah, just a few quickly, just briefly, three points. First one is the remote online mediation. Actually, when I did the joint seminar with the Hawaii Bar Association before as the vice chair of the international committee, even before COVID-19, they have been using the many online mediation. And actually, some of the mediators preferred online rather than the in-person, because they are saying like, okay, through the online camera, you can see face more closely rather than in person or something. You know, how you can catch the response or something. So that's just one remark. I mean, although majority is a kind of a negative or obstacles side is a remark. Then second, the win-win common interest seeking, for example, like standardization of patent or something. So Japan Patent Office and the Ministry of Justice would like to promoting the kind of Japan as the third neutral place for mediating. Including like JIMC's efforts, including the joint protocol with the SIMC, which the James Clarkson is also quite deeply involved. So such win-win facilitative type of business included discussion could be possible for such high-tech dispute resolution rather than the ongoing, never-ending disputes litigation in the multiple countries. Then third, for that purpose, Japan is also discussing deeply for the Singapore Convention signing. I think that could be a very, very good impact for the Japan for promoting the ADR, and I deeply promise to support Japanese government for those initiatives. That's my final word. Thank you.
Thank you very much. So great news on the Singapore Convention front from Japan, hopefully, and also Israel. I'm sure my dispute resolution colleagues who are lurking here, as well as Anna, are ecstatic to hear that good news. So thank you, everyone. Now, I see Takashi has popped back up on screen. Takashi, did you have anything to say, maybe logistic-wise?
Not much to add, but just wanted to quickly thank all the Day One speakers for all the excellent presentation, and Jay and I will be reflecting overnight on the presentation to give a short recap of the discussions today at the opening of Day 2. So yeah, look forward to seeing you all, and thank you to Atita for the eloquent moderating. Thanks.
Thank you very much. Thank you to all speakers. So with that, we are now at the end of the beginning, because today is Day 1 and tomorrow is Day 2. Please join us tomorrow. As previously noted, the link for Day 1 and Day 2 are the same. So speakers and participants, please use the same link to log in tomorrow at 5 p.m. JST or 10 a.m. CEST. We would be grateful if Day 1 speakers could join tomorrow's roundtable discussion, as Jay has some important and intriguing questions for everyone. And we will also be taking a group capture at the roundtable. So we hope to see you all there. With that, I think we can pretty much end. Jay, did you have anything to add? No, okay, no dancing for Jay today, but maybe tomorrow. So thank you again to all the speakers and participants for making today's discussions entertaining as well as educational. And see you tomorrow, everyone. Thank you.
Thank you very much.